Okay, I think we could begin because there are a lot of questions that we will be covering for tonight's session. Now, before I proceed, and we will be discussing the topic on separation of powers, will there be any question or anything else that any of you may wish to take up or raise? Because I think we have about 8 questions.
Can you just differentiate between quasi-judicial and quasi-legislative powers? I'm slowly getting my head around it, but I'm not quite there yet.
That's fine. Who asked that question? Sorry, was that John?
No, it was Nicholas, Manjo.
Nicholas. Okay, thanks, Nicholas. Okay, thank you for that question. I'm just going to mute everyone. And then if you wish to say something, just unmute yourself. Okay, so let's begin by talking about the difference between judicial and legislative. So if you're talking about legislative, it is the ability to legislate or to write laws or enact laws. When you talk about judicial, that's the power to actually adjudicate using the judicial powers, for example, of both the Commonwealth or of the states. Now, what makes it quasi-judicial, and I will explain this further in a short while, is that quasi actually means it's almost like. So when you say it's quasi, okay, I'm just going to open the chat box because I'm seeing some chat here. I can't view your screen properly. Okay, hang on. Give me a sec. I'm just gonna stop share, then share it again. Does that seem better? In terms of the screen, what's the chat saying now? Okay.
Yes.
Okay, very good. So when you say quasi, it means it's almost like. So when you say quasi-legislative, it's like it is as if the entity or the organization or the person wielding the power is almost like, as if it is like exercising legislative powers. In the same manner, when you talk about quasi-judicial, it is as if the organization or the agency or the entity is wielding or exercising judicial power. So let's begin with quasi-legislative powers. So quasi-legislative powers, typically the exercise of quasi-legislative powers would typically be associated with the exercise of those powers by the executive. So it often happens that the parliament would vest subordinate legislation to the executive to enable the executive to issue regulations or even bylaws that pertain to the primary legislation passed by the Commonwealth Parliament. So as a result, the executive then is in a position to create laws. And in that sense, it is wielding almost legislative powers, but not entirely, because the legislative powers actually belong to the Commonwealth Parliament. The other instance of the exercise of quasi-legislative powers by the executive pertains actually to the inherent powers of the Commonwealth Executive in relation to the executive powers, either based on Section 61 of the Australian Commonwealth Constitution, which expressly grants the executive the power to the executive power, which includes the power to execute and maintain the Constitution and the laws of the Commonwealth. The other aspect would be what we call the prerogative or reserved powers of the executive, and in relation to the exercise, therefore, of the executive of its powers, either under Section 61 of the Australian Constitution or of its prerogative powers, it then passes regulations or policies which actually have the quality or the character of a law, in the sense that it is binding and it has the ability to affect individuals within the Commonwealth, for example.
Manjo, can you give us an example of where the Parliament has passed powers to the legislator, and then the legislator has created pass powers onto a government department to create laws or of its own?
Yeah, it happens all the time. For example, if you look at the Immigration Act of 1958 Commonwealth, the Minister for Immigration, for example, actually has the discretion to grant citizenship to certain individuals, even if an individual doesn't really qualify for citizenship. So in particular, the proposed change, for example, under the Turnbull government is that for a person to become an Australian citizen, that person must have been a permanent resident of Australia, a permanent resident of Australia for 4 years. So prior to that change of policy, the requirement was that that person should have been a permanent resident at the time that he applied for citizenship. But at the same time, the requirement simply was that he was a lawful resident in Australia for the past 4 years, even if he had not been a permanent resident for 4 years. But the law itself, the Immigration Act of 1958 Commonwealth, gives the Minister for Immigration the power to issue regulations pertaining to instances when citizenship may be granted when the person applying for citizenship may actually suffer hardship. And you will see this almost in every single primary legislation created by the Parliament. And so if you look at the Dignan's case, which is the case of Australia C.V. Doring versus Dignan, the High Court has been quite clear that it does not go against the principle of separation of powers in Australia for the Australian Parliament to vest quasi-legislative powers or the power of to issue subordinate legislation to the executive. So the case is Australia C.V. Doring versus Dignan, or what is known as Dignan's case.
Does that apply to the states as well, though? Because are the states in the same boat of being able to create quasi-judicial and quasi-legislative powers?
There is less problem. There's less problem in the states, mainly because there is no separation of powers in the states. So if you look at Cable versus Director of Public Prosecutions, the High Court emphasized that the separation of powers, which applies in the federal system of government, is actually not present in the states. And for that reason, there is simply no restriction to the vesting by the Commonwealth Parliament, for example, of legislative powers on the executive. Now, there is more of a restriction, but not so much really. But there is, in a sense, an understanding that legislative powers are meant to be wielded only by the Commonwealth Parliament in the federal system, mainly because of the partial separation of powers in Australia. But as I said, following the Dignan's case, that really isn't true. Okay? So in the states, under Cable versus Director of Public Prosecutions, there is clearly no separation of powers. If you follow the Boilermaker's case, the High Court was quite clear that it will, so while Dignan's case tolerates the vesting of quasi-legislative powers on the executive, because as one of the High Court judges said, that is the only way for the government to function, because it's impossible, or it's not possible for the Parliament to actually provide the details of every single piece of legislation. And oftentimes, it is the executive, which is, by virtue of the departments that it has, is actually the executive which is in a better position to often flesh out the details of the primary legislation. Now, where was I? So so according to the Bowler's case, notwithstanding the Dignan's case, for example, the High Court in the Boilermaker's case was quite emphatic in saying that it will not tolerate, however, the vesting of non-judicial power on Chapter 3 courts. So when I say Chapter 3 courts, we're talking of federal courts. In other words, courts created under Chapter 3 of the Australian Commonwealth Constitution. And neither will the High Court, under the partial separation of powers in Australia, tolerate the vesting of judicial power on non-Chapter 3 courts. So those are the two main propositions or postulates under the Boilermaker's case. Now, you had a question, Nicholas, about 6:10, so we probably have enough time. you had another question about the exercise of quasi-judicial powers. So I was distracted with the chat there. I'll go back to the chat in a short while. So when it comes to quasi-judicial powers, there are two aspects to it. One relates to agencies or instrumentalities which are part of the executive, actually. For example, if you talk about the Workplace Commission, in a sense, it may wield quasi-judicial powers, because when there are parties that come before it for the purpose of trying to establish what the proper workplace conditions might be in relation to wages, hours of work, and so on, then in a sense, what it does is that it tries to resolve, or it tries to kind of adjudicate on the relative rights and liabilities of the parties. And in that case, therefore, it's in a position to kind of adjudicate. But in that particular case, that isn't really considered the exercise of true judicial powers, which under the Boilermakers case only belongs to Chapter 3 courts or federal courts. So the exercise, for example, of the Workplace Commission of what might be considered as adjudicatory, meaning, but so in other words, it's just quasi-judicial. So the exercise of quasi-judicial powers, for example, by the Workplace Commission in its ability to adjudicate on rights and liabilities of the parties before it, is only quasi-judicial, and it is not the exercise of true judicial power, because one, in that case, there is really no actual controversy between the parties. So it wouldn't fall in what is known as a matter which has been defined by the High Court, for example, in Moorhead versus in Haddad-Parker versus Moorhead, where there is an actual controversy involving rights and obligations or legitimate expectations between the parties, which has to be resolved on the basis of existing laws. In the Workplace Commission, for example, it is not on the basis of existing laws, but the possibility of new legal relations being created. So that is one of the differences between judicial as opposed to quasi-judicial. Judicial means the adjudication by the courts is on the basis of current laws, but the quasi-judicial bodies can actually try to adjudicate the respective rights and liabilities of the parties on the basis of what it perceives to be the proper relations between the parties. So it's in a position to create new relations between the parties, new rights even, for example, on the basis of an enactment. So that's one distinction. The other distinction, why it's called quasi-judicial, is that as far as the courts are concerned, when they exercise judicial powers, when they come up with a ruling or a decision, there is meant to be, that becomes a judicial precedent, or there is what is known as stare decisis, so that the decision of the courts are meant to be binding on other courts, especially of inferior courts. However, the decisions of quasi-judicial bodies actually relate to the specific instance of the parties appearing before it and are not binding. So there is no precedence, and any decision it makes is not really binding on any other parties, even if there might be a similarity of factual circumstances by the parties. So there's that other aspect. The other aspect, finally, the other aspect is that when courts exercise their judicial power, they're always meant to act judicially, in the sense that they have to act fairly and without bias. So when it says act fairly and without bias, or there's what is known as procedural justice, it means that the parties always have a right to a hearing. But in quasi-judicial bodies, it can happen that unless the legislation clearly provides for the rules of natural justice or procedural justice to be observed, it is possible for quasi-judicial bodies not to act judicially, except only when existing rights and obligations may be affected. So, I mean, I know I gave a very extended answer, but
it just seems that quasi-judicial systems and tribunals are making decisions between two parties.
Yes.
Which has no relevance to any other party, either in the past or in the future.
Yeah.
But is binding on those two parties and
Yes.
doesn't allow them to have any other recourse.
No. What do you mean by no other recourse?
Well, do they have the ability then to take the decision away from the tribunal, to another higher court?
Yeah, they do. They do. Because what we need to remember is that the exercise, so another example of a quasi-judicial body is actually the Administrative Appeals Tribunal. So what we need to remember is that it is possible for a quasi-judicial body to actually contravene the law. For example, one, it may be acting beyond its powers. In that case, if it acts beyond its powers, it is subject to judicial review. And courts can police the actions or decisions of a quasi-judicial body. It can also mean that it may be acting contrary to what the law provides. And again, judicial review is available for that. So there is in fact recourse, whether or not it is stated in the legislation that created the quasi-judicial body.
Yeah, but that's only in the case that particular body steps outside its judicial boundaries, right? To be able to make the so if it doesn't do that, if it doesn't step outside of that, where's the natural justice in that system?
Yeah. The other aspect we need to examine, Nicholas, is that there is what is known as the legal and the merits divide. So my reference earlier when I talked about the quasi-judicial body, and I'm more than sure the discussion right now is actually helpful because it does touch upon one of the questions in the midterm assessment. So what we need to distinguish, what I need to point out as well is that when I talked about the courts policing the decisions of quasi-judicial bodies in the exercise of its power of judicial review, I was actually talking, as I said, about the legality of the decision or the actions of the executive. But in fact, there will be instances when the decisions of the quasi-judicial body, especially in relation to the findings of fact, or in relation, for example, to its exercise of the discretion that has been given to it by an enabling law, can actually be subject to review. For example, by an application for review with the Administrative Appeals Tribunal. So in that case, when it comes to questions about the merits of the decision, or what is typically known as the correctness or the preferred decision when it comes to discretion, that is subject to review by the Administrative Appeals Tribunal. So there is a recourse.
Okay. Well done, Manjo. That actually cleared it up quite well. And I think I'll re-listen to this a couple of more times because I'm getting a broader picture now, and I think I'll draw a mind map. It might help.
Yeah. Okay. Thank you, Nicholas, for your question. And so I'd like to continue. So tonight, after this session, and if some others have other questions, we're going to have to delay it a bit because I'd like to cover most of the questions anyway. If we don't cover all these questions, I will post the suggested answers by tomorrow morning. So after this session, you should be able to distinguish and explain the operation of separation of powers at the federal and state levels, explain the weakening of the division of powers between the legislature and the executive, and the permissibility of vesting quasi-legislative powers on the executive, explain the guardedness of the High Court against encroachment into federal judicial powers. So I'm emphasizing federal because, as I said, there is no separation of powers at the states, so it's actually possible for state courts to be vested with non-judicial powers. So that should be quite clear because that comes up in the midterm assessments. Finally, explain the concept of judicial power in relation to the High Court's strong resistance against the vesting of non-judicial powers in Chapter 3 court. So let's go through this. PQR Enterprises seeks, and I'm just going to look at the chat a bit later. I'll go back to your point, Monique, in a short while after I go through the questions, if that's all right. So PQR Enterprises seeks to appeal from a decision of the Business and Commercial Establishments Tribunal, which is an administrative tribunal created by Parliament under the Business and Commercial Establishments Tribunal Act, Commonwealth. PQR seeks to ground its appeal on the fact that the tribunal failed to follow the rules of natural justice by preventing it from presenting crucial evidence in its proceedings, as his or her solicitor advised PQR enterprises on the matter. You could answer the question by picking up the mic or by putting your answer in the chat box.
Quickly, just speaking of answers,
Yes.
Joe, I noticed there's no quiz in this week's section on Moodle.
There is. It was posted on Monday.
Not that I can see, not in mine.
Is that right? Have the others experienced the same problem?
I can see it in mine.
Okay. Yeah, it should be there, Nicholas. It should be in the assessment block, in fact. So you're going to have a look again. It should be there. Yeah, oh, in the assessment. Yeah, we're still in quiz 3. Yeah, it's in the top hand left corner, assessment block. Okay. Any volunteers? And we're just going to go quickly through this. Anyone who would wish to answer question 1?
Yeah, Manager, I'll have a go.
Gary, thank you.
It's so I'd say that PQR has a strong case in that if its allegation that it was precluded from presenting crucial evidence goes contrary to the principles of natural justice, namely that the decision makers must act fairly, impartially, and without bias. Furthermore, the principle of audi alteram partem has not been complied with in that if it is correct that PQR was prevented from leading crucial evidence, it cannot be said that PQR was afforded a fair hearing as it is materially affected by the decision of the tribunal.
Thank you, Gary. Any contrary opinion from the class?
No, I'll vote with Gary, Manjo.
Okay. Was that Nicholas? Okay. How about the others?
Thanks, Nick. Thanks, Nicholas.
I wish you would just come up with the answer based on the popular vote. Others? A contrary opinion? Okay. The first question that needs to be asked is, this particular tribunal, is it a Chapter 3 court or is it an administrative tribunal, meaning belonging to the executive?
It's an administrative tribunal, isn't it?
It is. So what we need to remember is that it is only in general, it is only the courts which are required to act curially, or in other words, which are required to act according to the rules of natural justice in general, only courts. Now, the administrative tribunals in general are not required actually to observe the rules of natural justice unless one, the legislation specifically provides that the administrative tribunal must observe the rules of natural justice, or two, when its actions can be said to impair the rights and obligations of a party before it. So there are only 2 instances where the rules of natural justice, for example, the duty to provide an opportunity to a party to be heard, will only arise, for example, in the case of Kiowa versus West, decided by the High Court. The requirement that the rules of natural justice should be observed will only arise when the legislation creating a tribunal specifically provides or can impliedly be said to provide that the rules of natural justice will be observed, or two, when the decision of the tribunal is said to impair the rights and obligations or legitimate expectations of a party before it. Now, in this particular case, it can be seen that the tribunal is not a Chapter 3 court. So in general, it is not required to observe the rules of natural justice. And so the answer would be that unless the enactment creating the tribunal specifically or impliedly provides for the rules of natural justice to be observed, there is no requirement that the rules of natural justice should be observed.
So what you're saying is we'd have to look into that Establishment Tribunal Act first and see what the...
Yes.
Yeah, okay.
So when you answer, you can make an assumption. For example, you would say, my advice would depend on whether the enabling statute requires the tribunal to observe the rules of natural justice, because following Kiowa versus West, there is no requirement for an administrative tribunal to observe the rules of natural justice, unless the enabling law provides, or two, its actions or decisions actually infringe or impair the rights, legitimate expectations or interests of a party before it.
Well, I think I'm still going to go with Gary Manjo, and I think we both just assumed it was written into the Establishment Tribunal Act that they
yeah.
See?
Yeah, so what you need to do is that when there is a question such as this, you need to be explicit with your assumptions, because you cannot assume that that rule is provided, that requirement is provided in the law. So
yeah, not without looking at the law.
Yeah, if you did not make that assumption explicit, the answer can be said to be wrong. So it has to be there.
Understood, Manja. Thanks very much.
Okay. Question 2. So I'm just gonna read the questions. It'll be faster for us. Under the Refugee Resolutions Act Commonwealth, some judges of the federal court were designated as eligible judges of the Refugee Resolutions Tribunal, with the power to issue warrants for the indefinite detention of undesirable aliens and refugees. The Act provides that the Attorney General and the Minister of Defense have mutual authority to make binding and conclusive designations of persons as undesirable aliens and refugees. Ms. EFG, who was detained under the Act, filed suit with the High Court questioning the constitutionality of the Act, ruled on the Act's constitutionality without going into the question of implied rights and freedoms, just in relation to the notion of separation of powers. Okay, so we've got an answer here from Kathleen. Not constitutional due to taking on judicial powers. Okay. How about the others?
Mando, is this quasi-judicial body that you're talking about before?
This one, you mean? This particular question? Okay.
Yes, so refugee resolution.
That's right. Instead of me answering that question, Leonie, I'd like to throw the question back at you. What do you think? Is that an administrative tribunal or not? Or is that a Chapter 3 court?
Well, it's not a Chapter 3 court because it's a tribunal, but
yeah.
I don't think I fully understand the concept of the judicial just yet.
Okay.
Until I can get back to listening to what you said at the start of this, which is why I asked the question, that was all.
Okay. So, I mean, definitely this, it's easy to know whether or not a particular tribunal, so even if an agency is called a tribunal, it is possible for the tribunal to actually be a Chapter 3 court. So it is not the nomenclature which is determinative of whether or not it is a Chapter 3 court. We will know that a tribunal or an agency or a body is a Chapter 3 court if it has been constituted according to the requirements of Chapter 3. So that's in relation to the appointment, it's in relation to the security of tenure, it is in relation to the removal from office, which means that Chapter 3 judges can only be removed on impeachable grounds, according to the Constitution, before a proceeding before the Parliament. So there's that requirement. So in other words, if an agency or a tribunal or a body is created not in accordance with a Chapter 3 court, in accordance with Chapter 3 of the Constitution, it cannot be a Chapter 3 court. It cannot be a federal court. So in this case, we will assume that, because it doesn't say, we will simply assume that this is not a Chapter 3 court. So it is an administrative agency. We can make that quick assumption. So if you make a quick assumption that this is not a Chapter 3 court, rule on the Act's constitutionality, at least in relation to the principle of separation of powers. So we've got an answer from Monique. She agrees with Kathleen that this is unconstitutional because it is taking on judicial powers. Okay, how about the others?
Manjo, I'd like to throw something in there. I don't know if it's right.
Okay.
I'm just wondering about the fact that it was the Attorney General. Correct me if I'm wrong, that brings in the executive government there, doesn't it?
Yes, go on.
And the executive government has a right to, the executive government in its power has a right of certain powers. So I'm sort of going to say, well, it is constitutional, but there's nothing stopping Ms. EFG from trying it out in a court.
Okay, but I'd like to ask the question, Erin. What is the legal issue here? What is potentially, what can potentially make the act unconstitutional?
I guess, it's whether it comes under a certain head of the Constitution, under one of the heads of powers of the Constitution. I guess it goes back to basically, is it constitutionally valid under the heads of power that you would need to trace it back to, which at this point in time I have no idea which one it is.
Okay. Okay, how about the others?
Manjo?
Yes.
I just want to find out, does the High Court have jurisdiction in this case?
Does the High Court have jurisdiction in this case?
Yeah.
Well, if you look at Section 75 of the Australian Commonwealth Constitution, the High Court has jurisdiction, as original jurisdiction in all matters where, for example, an officer of the Commonwealth is a party to a case before it.
Okay.
So
how does that sit with Section 73?
Yeah, so Section 73 would relate to the power of the Commonwealth Parliament to create Chapter 3 courts.
Okay.
So in this particular case, if the action is against the Attorney General and the Minister of Defense, that falls within Section 75, subparagraph 3. If you look at Section 75, subsection E as well, it grants the High Court the original jurisdiction in relation to matters where a writ of mandamus or injunction is actually sought.
Okay.
So prohibition, mandamus, or injunction. So again, the High Court has jurisdiction. If you look at Section 39B of the Judiciary Act of 1903 Commonwealth, that particular law also provides that the Federal Court of Australia has original jurisdiction over those actions where the High Court under Section 75 of the Australian Commonwealth Constitution exercises original jurisdiction as well. So both the High Court as well as the Federal Court, on the basis of Section 39B, would actually have jurisdiction to entertain this suit. So the question really here is, the question is, number one, let's clarify this. So in this particular case, what has happened is that judges of the Federal Court were designated as eligible judges of the Refugee Resolutions Tribunal. We will recall that according to the Boilermaker's case, the High Court was clear that it will not allow the vesting of non-judicial powers on Chapter 3 courts. Do we remember that? So it is not permissible for non-judicial power to be vested on a Chapter 3 court. Here, the power, for example, to issue warrants for the indefinite detention of undesirable aliens and refugees involves the exercise of non-judicial power. Let's be clear about that, okay? I'm just gonna make it, I'll simplify it. That involves the exercise of non-judicial power because there is no matter. There is no actual controversy before the tribunal. The tribunal on its own is issuing a warrant, even in the absence of an actual controversy. So that involves the exercise of a non-judicial power. The question then is, since this tribunal obviously exercises non-judicial powers, is it constitutional for that particular act to enable judges of the federal courts to exercise non-judicial power? Because it seems to run afoul of the Boilermaker's case. And the answer is the law is actually constitutional, because the court, in the case of Drake versus Minister for Immigration and Ethnic Affairs, Hilton versus Wells, and Grollo versus Palmer, ruled that under the persona designata doctrine, for as long as a member or a judge of a Chapter 3 court agrees or consents to undertake non-judicial functions in his own personal capacity, then that is permissible. So it is. There is nothing invalid about the designation of a judge in his personal capacity to undertake non-judicial functions. So if he agrees, so there must be consent. So there is a personal designation in his own personal capacity. There has to be consent from the federal judge. And thirdly, that the actions of the federal judge in his personal capacity undertaking non-judicial functions will not bring the federal courts into disrepute. So in other words, for as long as he does not become an instrument or a tool of the executive under the doctrine of persona designata, then such a designation would be valid. Now, in this particular case, there is a potential problem because the Attorney General and so there is the second issue that given the facts, it would appear that the Attorney General and the Minister of Defense have the power to make binding and conclusive designations. And because these are binding and conclusive, it is as if they can rubber stamp decisions and just compel the judge to issue the warrant upon the finding of the Attorney General or the Minister of Defense that a person is an undesirable alien or refugee. So that will go against the statement of the High Court in Grollo versus Palmer that there must still be independence exercised by the federal judge, and that his actions in undertaking in his personal capacity non-judicial functions should not put the judiciary in disrepute. In this case, it is because it becomes almost as if a tool of the executive, then that puts into question the question of impartiality and protecting the integrity and independence of the judiciary. However, it can be argued that in this particular case, it is still possible for the actions of the Attorney General and Minister of Defense to be read as if that whilst they may make binding and conclusive designations, there doesn't seem to be anything to suggest that the judges, as part of the tribunal, really don't have the power to actually review the designations made by the Attorney General and the Minister of Defense. So in other words, we make a distinction between what is known as an ouster clause as opposed to a privative clause, as I think we're currently looking at in chapter 6 of the book. So the ouster clause is a way of reading a provision that a person or a body simply does not have jurisdiction at all, as opposed to trying to delimit the interpretation of a provision so that what can be said is that there are limits to when jurisdiction may actually be undertaken. So for as long as it can be said that this is not an ouster clause, but it's simply a privative clause, which therefore delimits the areas around which an eligible judge may review a decision or a designation by the Attorney General and the Minister of Defense, then there is nothing unconstitutional about the Act. Okay, so moving on to question 3. The Attorney General has invited 3 senior members of the Federal Court of Australia to act as advisors to the Attorney General's Department in the discharge of its national security responsibilities. In particular, such consenting senior members shall provide advice to the Attorney General's Department on the legality of its operational guidelines and procedures, determine the validity of such designation.
It's valid.
Who'd like to say something?
I said it's valid, Manjo.
Very good. Why, Erin?
Because again, he's from the executive. He invited the judges, so they weren't forced into it.
Very good.
And they're only providing advice to the Attorney General. They're not determining facts of law.
Mm-hmm. Okay, but we haven't addressed the problem about the vesting of non-judicial functions of these judges, and that is the legal issue there.
Can I go against that
John?
supposition?
Yeah.
I would say it's not valid.
Go ahead.
Because it clearly breaches the separation of powers between the judiciary and the executive.
Okay, why?
Because they are being asked to give advice on a legal issue.
Go on, yeah.
This is a little bit like Chief Justice Mason being asked to give advice to Sir John Kerr about the Whitlam government. That's
okay. Okay, that's right. Now, but John, my answer would be that the designation is actually valid on the basis of the persona designata doctrine. So what we need to recall is that under the persona designata doctrine, for as long as the designation, so even if a judge of a Chapter 3 court is vested with non-judicial powers, for as long as the designation of such a judge is in his personal capacity, and 2, it is with his consent, and 3, the judge is still able to act impartially and with independence, then there is nothing legally objectionable to such a designation. But you are correct in raising the case of Chief Justice Mason providing hypothetical advice to Sir John Kerr when former Prime Minister Gough Whitlam was removed from office. So because in that case, a lot of the commentators would say that, courts should only come when there is an actual controversy, when there is a matter before it. And that was an instance when, that was purely hypothetical. Now, but this one is different because this is where the persona designata doctrine really applies. Now, what happened in the past in relation to Gough Whitlam, is one of those curiosities in Australian constitutional law. If that were the question, whether it was proper for Chief Justice Mason to have done what he did, because it possibly violated the principle of separation of powers, that's an open question that continues to be debated today, because there are those who argue that it is part of constitutional law practice or part of convention, actually, for prime ministers to go to a high court judge to ask for informal advice in a very informal capacity.
Sounds more like a moral issue to me, Manjo.
Yeah, okay. Can I just address the point here by Catherine? In the last question, how can providing warrants be acting as a person and not as a judge? Okay, so wait, Catherine, are we talking about the previous question or this one? So in relation to the previous one, so in relation to the previous question, in the case of question 2, the eligible judges here, although they're judges of the federal court, are actually no longer acting as judges in the tribunal. They can't, because their role here is simply as a member of the tribunal, and they are not acting as a judge of a Chapter 3 court. And so in that case, therefore, the involvement of these eligible judges in the tribunal is really in their personal capacity. It has nothing to do with a Chapter 3 court. It has nothing to do with there being federal judges of a Chapter 3 court. So which is why the designation is in relation to them in their individual capacity, although they happen to be judges of Chapter 3 courts.
I think the confusion here, Manjo, is that these judges are on this tribunal, and aren't they the ones, in essence, making the decisions that are bound by the parties to that tribunal?
Yeah, I mean, I know what you're saying, Nicholas, and you're right. But what I want to do here is to be able to state the law. Okay, So the law here, and if you examine, for example, the Administrative Appeals Tribunal, and that which is a federal administrative tribunal, you will realize that the president of the Administrative Appeals Tribunal is a senior judge of the federal court. So there are judges of the federal court, which are presidential members of the Administrative Appeals Tribunal. And remember, the Administrative Appeals Tribunal is not a Chapter 3 court, so they're definitely undertaking non-judicial functions. So you wonder, how is that possible? And the answer is, it is possible because of the persona designated doctrine. Now, whether or not we agree with it, we're going to have to delay the debate. I am just stating for the record that that is the law. So we have the Boilermakers case, where the High Court has said that it is impermissible for a for non-judicial power to be vested in a federal judge or in a Chapter 3 court. However, the cases of Grollo versus Palmer and Hilton versus Wells have also clarified that under the persona designated doctrine, it is permissible for non-judicial power to be vested in Chapter 3 judges in their personal capacity for as long as they consent to it, and the exercise of the non-judicial functions by those Chapter 3 judges do not impair the independence or impartiality of those Chapter 3 judges. Okay, so
Banjo, it's Gary. I just want to confirm something in problem 3. So
Yeah.
are you saying that the advice that the judges are giving to the Attorney General's Department, is that advice non-judicial in nature?
it's definitely
For
not.
purposes of question 3.
So
Sorry?
in relation to question 3, when the senior members who are members of the Federal Court of Australia provide advice to the Attorney General's Department, that is definitely a non-judicial function.
Okay, no, I understand. Thanks very much.
Okay, so it is not a non-judicial function because there is no matter.
Okay.
So if you follow the case of Hunter Parker versus Moorhead, judicial function is implicated when there is a matter before the court. There is a matter before the court when there is an actual controversy involving the rights and liabilities and respective obligations of parties before it. Here, there is no actual controversy, there is no matter, because it's just providing advice.
So what you're saying, Manjo, is if there is a controversy before a Section 3 court, and one of the...
Chapter 3 court, you mean, Nicholas?
Sorry?
Chapter 3 court.
Yeah, the Chapter 3 court. So if there was something going on in a Chapter 3 court...
There's a matter, yeah.
Yeah, that one of the judges that was also giving advice to the Attorney General on a similar matter was involved with, where does that then put the judge's ability on persona?
Okay, so in your hypothetical scenario, what you're actually saying is that let's assume that a person was probably a member of the Administrative Appeals Tribunal, and there was somebody who appeared before him. Okay. Now, what we need to remember is that the cases before the Administrative Tribunal are not considered matters because there is no actual controversy. The applicant there is an individual. He's not really filing a case against. There is really no clear respondent, such as a Commonwealth agency, even if there appears to be a respondent. So the respondent Commonwealth agency, for example, is just there in a formal role, but actually.
Yeah, I understand that. What I'm trying to get at is if there was an action in a Chapter 3 court that was taking place before a particular judge.
Yes.
And that same judge.
Yes.
Also on one of these
yes.
councils, where does that put the judge in an ability to be able to make a decision in the Chapter 3 court and at the same time be a party to making a decision within a tribunal?
That's a very good question, but it happens all the time. What typically happens, what we need to remember is that it doesn't mean that when a judge becomes part of an administrative tribunal exercising non-judicial functions, it doesn't follow that such a designated judge necessarily becomes partial. He's actually sitting there because he's actually been invited because he is understood to be impartial. And he is invited there because he knows the law. Now, what it also means is that even when a judge sitting, for example, as part of the administrative tribunal, renders a decision as part of that administrative tribunal, it doesn't have to mean that that judge is necessarily, arguably, we can argue that it doesn't follow that that judge is necessarily wedded to any decision that he makes. So when, for example, when there's an application for judicial review that goes to the federal court from the Administrative Appeals Tribunal, assuming that the sitting judge of the AAT becomes a judge, is a judge as well at the federal court, if the judge, there's no requirement that the judge has to inhibit himself, and there is still the assumption that the judge is faithful to the law. He's going to be, the judge will be making a decision on, what is legal. So which is why, as far as the High Court is concerned, it has not seen any problem in relation to the separation of powers with the notion of the persona designata doctrine.
Right, I got it. I just really think that in that sense that judge should recuse himself.
There is no requirement. There is no requirement
for it, which is, yeah, which I think is where these morality issues come into play in people's minds.
Yeah, but we're going into the question of political science. But as far as the law is concerned, there is really no requirement for that.
Yeah, no, I understand that very clearly now, Manjo. Thank you very much.
Okay, yeah.
I think, Manjo, the issue from my understanding is judges are meant to be impartial. If they aren't, who is going to be? And secondly, it's, you look at the capacity, the role that they are fulfilling in their two different spheres.
That's right. Yeah, that's right. So they're actually enlisted to join the administrative tribunal because they're known to be impartial. In fact, if they were not to be partial, that would go against the persona designata doctrine of Grollo versus Palmer, which is an exception to the Boilermaker's case. Now, I'm conscious of the time, it's 6:52. I'm just going to skip to a part there which I think is relevant to you in relation to the assessments. So I'm going to go to question 5 because this is relevant to the assessments and it can be helpful. So the Queensland, and I don't think we'll be able to finish all the questions, which is fine. I'm going to provide the answers later on. Okay, so the Queensland Parliament passed the motorized, and it's okay for us to extend a bit because my class starts at 7:15 if you want to stay on. But this is recorded, isn't it? Okay. So the Queensland Parliament passed the Motorized Criminal Syndicates Act Queensland that vested on the Queensland Political Tribunal a power based on strict criteria and guidelines to designate certain organizations as motorized criminal syndicates engaged in serious crimes and issue an order for the seizure of their assets. Under the Act, hang on, I don't think this is the one I wanted to look at. Give me a second. Now that's easy. Was that the one? Hang on.
Was it 9, Manjo? Or sorry,
Yeah.
question 7?
Was it? I'm just looking. I'm just trying to.
Oh no, sorry.
I was trying to look for something that's relevant to your midterm assessment. So let me just have a look.
You got to give us one easy one, Manjo. Come on.
No, though. Are they actually difficult? Hang on, give me a second. I thought it was here. Give me a second, sorry. Because we don't have time. Just wanted to jump into that particular question, which is related to. Give me a second, sorry.
That one there is similar to one of the questions, Manjo.
Is it this one?
Unless I'm confusing with another question for next week in the sessions.
I don't think it's the one. I wonder where it is. I thought I created a question. Okay. I thought it was this one. Can I just create a different question, if that's all right? Because
yeah,
I thought
it's similar to question 2 in the individual assessment, Manjo.
Oh, is it?
Because this one talks about a Queensland anti-terrorism agency.
Yeah, but this appears to be a different legal issue here. This appears to be a different legal issue here. Okay. Oh, yeah. It might have been, I might have been thinking of the actual assessment. Anyway, so let's...
Keep going then, Manjo. You weren't thinking of the...
Let's just look at question 7. Okay, I just want to emphasize something here. I thought I had it here, but I seem to have missed it. Because this is a crucial point, okay? This is very important. Whether or not I give you an example, but this is a crucial point. The Boilermakers case, which emphasizes that it is impermissible for the vesting of non-judicial power on Chapter 3 judges, and it is impermissible for judicial power to be vested in non-Chapter 3 courts, okay? That particular ruling applies only in relation to the federal courts. Are we clear? So, if the question relates to whether or not it is legally permissible for a state parliament to vest non-judicial power on its state judges, the Boilermakers case does not apply. So let me repeat. The Boilermakers case is in relation to the question of whether or not it is legally permissible for non-judicial power to be vested in a Chapter 3, meaning in a federal court. The other question is it permissible for judicial power, Chapter 3 judicial power, to be vested in a non-Chapter 3 court? So the point there is that as far as the Boilermakers case is concerned, it applies only to the federal judicial system, to the federal judicial power. Are we clear? Now, however, the Boilermakers case does not apply to the state courts. So in other words, because of the absence of the separation of powers in the states, it is permissible for state parliaments to vest non-judicial power in state judges, in state courts. That is legal. It is also legal for state parliaments to vest judicial power in a mere tribunal. So which is why, for example, if you look at the Queensland Civil and Administrative Tribunal, that particular tribunal is exercising non-judicial power and judicial power at the same time, because in the states there is no separation of powers. Okay, so any other questions? We could go on with questions. Yes.
But Manjo, that separation of powers applies to Supreme Court if they're dealing with a matter of federal jurisdiction.
That's right. Fantastic. Thank you, Rian. That's correct. So, if you follow the notion of judicial integrity, which was articulated clearly by the High Court in Cable versus Director of Public Prosecutions, even if state Supreme Courts are creations of the states, so even if state Supreme Courts are not Chapter 3 courts, so in other words, they are not federal courts constituted under Chapter 3, because they are part of the integrated judicial system in Australia, it would be impermissible to vest certain powers in the state Supreme Courts where their integrity and judicial independence would be questioned, and which would then bring into disrepute the entire federal judicial system, of which the state Supreme Courts are actually part of. Very good, Rin. Thank you.
So Amanda, is that...
yeah, so I have a comment here from Amanda. I'm going to have to watch this again later.
Okay.
Yeah, really, I need to emphasize that there are so many exceptions, so many howevers, which I've noticed somebody saying here, in constitutional law, in particular in relation to the separation of powers. You need to read and reread the textbook and the study guide, and probably watch and rewatch this Zoom recording. Yeah. Yes. Did you make a statement, Gary, or was it Nicholas?
Yes, I just wanted to find out what you said about cable and compromising the integrity of the judicial system in Australia.
Yes.
Is that what you referred to as the autochthonous doctrine in your notes?
Yes, it is.
Okay, thanks.
Very good.
Okay, thanks.
Okay. Yes.
Sorry. I guess I have a question then to clarify something in the assessment where it talks about the vesting, Queensland State Parliament has vested powers in their state courts, in the judges of state courts, something along those lines.
Yeah.
Are we talking about state courts that exercise federal jurisdiction or not?
I think did I say state Supreme Court there, or did you just say
you
state?
didn't, just said state. It didn't say supreme.
Okay. Because it's really part of the assessment, I have difficulty answering that particular question.
Okay.
But again, at the end of the day, the other question I ask is, does it really matter? So I go back to that question. In other words, does it matter if the vesting of non-judicial power is to the state Supreme Court or is to another state court, a lower state court? Does it really matter?
No, because it's not under federal jurisdiction.
Yeah.
Okay, thank you.
Good question, Monique, and thanks, Nicholas, for providing that answer. But so I'm not sure if I'm really giving away the answers here, because as it happens, we're just discussing, and I haven't really provided an answer to any of the questions in the first place. So what I've simply done is to try to expound on certain concepts that are meant to be covered in topic 4.
I think I can see why some other unis do it over 2 semesters, Manjo, and leave it till later now, because it is so brain intensive. And with a person like me who's doing 4 subjects at once, it's like full on.
Yeah, it is full on. Constitutional law is full on, really. It is.
Anyone who says it's dry is not thinking.
Yeah.
It's definitely not dry. It's
constitutional is very complicated. Wait until you get to the state and federal relations. It becomes even worse.
So then, Amanda, can I ask you a question? Which one's harder, constitutional law or administrative?
Constitutional law is much, much harder. Administrative law is easy. Administrative law is easy in comparison to constitutional law. Yeah, constitutional law is really difficult. Because not difficult in the sense that it's difficult to understand. There are just, well, maybe it's difficult to understand because of the many concepts that are there and the many high court cases which kind of almost like conflict with each other. Yeah. Okay. So it's 7:03. I think this might be a good time to end tonight's session, if that's all right. Because I've got a class coming up in a few minutes, and I think some of you are beginning to drop out because you've got tutorials as well at 7. Unless you've got other questions, then, we'll call it a night.
No more questions, Manjo. Unless you're going to give us the answers, we'll just.
I'm sure you'll figure it out, Nicholas. You find it easy. Yeah, with that discussion tonight, it should be easier to answer the midterm assessment. Well, hang on. After a while, things will make more sense. A lot of these things, a lot of these concepts are quite unfamiliar. You're going to come across them for the very first time. So they're kind of surprising, but after a while, you keep on hearing this and I keep on emphasizing them, you will get them. After a while, it just becomes second nature. And things will be easier as we move on. So you can't judge the difficulty of the subject on the basis of the first few weeks. It's like, no matter what you do, whether it's trying to do a marathon or trying to lose weight, the start is always difficult, and then things just become easy. Whether it's about, learning how to drive, doing the guitar, whatever. It's always the start that's easy, but I can assure you, as we move on, things will become easier. Okay, so with that, good night.
Manjo.
Yeah.
Thanks, Manjo.
Quickly, just before you go,
yeah.
I got the email today from you about the groups being changed again. Is that right?
Not that the groups. So the groups that are okay will not be changed.
Because have you done the Excel spreadsheet again?
I'm going to do that tomorrow. There will be changes only on two conditions. There will be a change when some of those groups have fallen down to less than 3.
Yeah.
So something has to be done. And in that case, I will be combining some of the groups.
Yeah.
But for the groups that are functioning well, I won't touch them for as long as there's a minimum of 3 members there who are still active and enrolled in our class.
I had a look at it today thinking that you'd done it. And
No, I'm gonna release it tomorrow. Yeah.
All right, I'll have a look again tomorrow.
Okay, so apologies about the confusion because of the changes in the groups. So I should have thought about the fact that there'll be upheavals in the group compositions after census date. It never occurred to me. So in future, when I do group work, I'll have to make sure that any group activities happens after census date. So I apologize for that. I should have thought about it. Okay. So yeah, thanks, Amanda. So have a great weekend, and I'll see you again next week. Bye. Good night.